another lawsuit, and we understand that Meghan is disappointed over this particular lawsuit. Why? Because now these lawsuits are going to drag out until 2026.
With Meghan, Duchess of Sussex. Associated newspapers had been appealing against the ruling not to hold a full trial after the paper reproduced parts of a handwritten letter from the Duchess to her father, Thomas Markle, in 2019. Our correspondent Helena Wilkinson
ended up in the pages of the Mail on Sunday and on Mail Online. Not the whole letter, just pieces. Carefully selected pieces that painted a particular narrative. Meghan's legal team, led by attorney Michael Kump, argued this was a triple-barreled assault on her privacy, her family life, and her correspondence rights. The High Court agreed. Judge Warby issued a ruling in 2021 stating that Meghan had a reasonable expectation of privacy in the contents of that letter. The court found that printing it constituted a breach of privacy and copyright infringement. But here's where it gets interesting. The court awarded Meghan damages, but not massive damages. The financial compensation was relatively modest. What mattered more was the precedent. The ruling established that even public figures, even royals, have fundamental privacy rights. The Mail on Sunday appealed. They argued that Meghan, as a public figure, had waived her privacy rights. The appellate judges rejected that argument. They upheld the lower court's decision in May 2022. The victory was significant, but notice what didn't happen. The media narrative didn't end. In fact, the letter controversy faded, but the questions lingered. Why did Meghan's relationship with her father deteriorate so publicly? What did the letter say that was so inflammatory it needed to be published? The legal victory settled the privacy question, but deepened the curiosity about her family dynamics.
Going away, it's that in Netflix and Oprah and some other stuff, horrible things were said about her.
Now, while the Associated Newspapers case was playing out in British courts, a different kind of battle was unfolding across the Atlantic. In California, Meghan and Harry were taking on paparazzi agencies. And this is where things got brutal. In January 2020, paparazzi took photos of Meghan in a public park in Vancouver, Canada, carrying their then 8-month-old son, Archie. But these weren't candid shots from a distance. These were long-lens photographs taken from afar. Intrusive, invasive. The photos ended up distributed by Splash News, one of the world's largest photo agencies. Meghan and Harry sued. Their legal argument was straightforward: invasion of privacy. The couple argued that photographing their child without consent, using telephoto lenses from hidden locations, violated their reasonable expectation of privacy, even in a public space. Here's the kicker. Splash News, facing the legal onslaught from the Duchess of Sussex and the Duke of Sussex, with their army of expensive lawyers, filed for Chapter 11 bankruptcy in America. The company literally couldn't afford to fight this battle. After years in the business, a single lawsuit from two royals pushed them into financial collapse. The settlement was undisclosed, but the message was clear. Meghan and Harry would fight. They would litigate. They would pursue cases aggressively. But was it just about privacy? Or was it also about sending a signal? Don't mess with us. Similar settlements followed with other paparazzi agencies. X17, another photo service, issued a public apology after settling their lawsuit with the couple. The pattern became unmistakable. When paparazzi captured images of Archie, the legal team mobilized. Every invasion of privacy met with aggressive legal response.
Enjoying a formal apology from a UK tabloid after beating it in court. She sued the Daily Mail for breaching her privacy. Let's bring in now our justice correspondent, Candace Kelly, for more. Good morning, Candace.
Good morning.
This apology was actually part of a settlement. Remind us of this backstory.
Well, this happened at a time in terms of the invasion of privacy issues that have come up, as well as.
But here's where the story takes a different turn, because not all lawsuits are victories. Not all legal battles end with settlements or favorable rulings. Some drag on, some reveal deeper fractures. Samantha Markle, Meghan's estranged half-sister, filed a defamation lawsuit against Meghan in March 2022. Samantha claimed that Meghan made false and damaging statements about her in interviews, particularly in the Oprah interview and in the Harry and Meghan Netflix documentary series. Samantha alleged that Meghan portrayed her as a villain in their family narrative, making defamatory statements that harmed her reputation and livelihood. The lawsuit specifically cited comments Meghan made, characterizing Samantha as abusive and difficult. Samantha argued these statements were false and deliberately designed to damage her credibility and public image. It was family warfare through the court system. In March 2024, a federal judge in Tampa, Florida, dismissed Samantha's defamation lawsuit against Meghan. The judge ruled that Samantha had failed to adequately plead her case and that her claims were insufficient under defamation law. It was with prejudice, meaning Samantha couldn't file the same claims again. Meghan had won, but Samantha didn't accept defeat. She appealed. And in September 2025, just recently, her legal team appeared before the 11th Circuit Court of Appeals in Jacksonville, Florida, for oral arguments. This time, Samantha's attorney, Peter Ticktin, argued that the lower court had made legal errors. He contended that Meghan's statements were intended to destroy Samantha's credibility and should be actionable under defamation law. The appellate panel appeared skeptical. During oral arguments, judges pressed Samantha's legal team on their arguments, pointing out inconsistencies and gaps in their legal theory. The outcome remains pending, but early indicators suggest Samantha's appeal may fail. What does this tell us? That even legal victories don't end the conflict. The family rift, once public, becomes litigated. Claims and counterclaims, statements and characterizations, all become evidence in a legal proceeding.
The Duchess of Sussex, Meghan Markle. We can go live now too.
When you step back and look at all these cases together, a pattern emerges. And this is the crucial observation legal experts have been making for years. Meghan's legal team doesn't just defend, they attack. They don't wait for court orders, they initiate them. Cease and desist letters go out constantly. Lawyers threaten action. Media outlets receive warnings about purchasing paparazzi photos. It's aggressive, it's proactive, it's comprehensive. Compare this to how other royals handle similar situations. Kate Middleton has faced paparazzi intrusions. She hasn't launched the same volume of lawsuits. Prince William has dealt with tabloid coverage, yet his legal response has been more measured. But Meghan operates differently. Her strategy appears to be sue first, settle later, and make examples of anyone who crosses certain lines. Is this smart legal strategy? Absolutely. Does it protect her interests? Undoubtedly. But does it also send a message? Does it also contribute to a particular public perception? These are the questions being asked in legal circles and in the media. Some argue this aggressive approach is necessary because tabloids, particularly in Britain, have historically shown little restraint. Others argue it's excessive, that it contributes to Meghan's image as litigious, as someone who weaponizes the legal system to silence critics and punish adversaries. The truth likely sits somewhere in between. Meghan has legitimate privacy concerns. She's been the subject of intense media scrutiny. But the sheer volume of legal action, the aggressive posture, the willingness to pursue cases that stretch legal precedent, these characteristics define her relationship with the legal system in ways that are hard to ignore.
Back in a London court again this morning as he fights a ruling that means his police protection has changed when he visits his homeland. Maggie Ruli's in London. Good morning, Maggie.
Hey, George, good morning. Yeah, Prince Harry is in court right now for what is day 2 in his case against the British government and what is essentially his last chance to change their stance on his security status. Now, since Harry is no longer a working royal, the government here decided to change his security protection, offering him that state-funded police protection on a case-by-case basis only. It's something Harry's lawyers argue is simply not enough. Now, guys, Harry could hire his own security team when he visits, but under UK
Here's
law...
what people don't often discuss openly. The cost. Not just financial, though that's substantial. We're talking about lawyers billing at $1,000 an hour or more. Cases that drag on for years. Legal bills that accumulate into millions of dollars. Meghan and Harry can afford this. Most people can't. But even for them, the financial burden is significant. Then there's the reputational cost. Every lawsuit gets covered by media. Every court filing becomes a news story. Every ruling, whether favorable or unfavorable, reinforces certain narratives about Meghan. She's litigious. She's thin-skinned. She weaponizes the legal system. These are the characterizations that follow her through the media ecosystem. The Samantha defamation case is instructive here. Even though Meghan won at the trial level, the case itself became a narrative about family conflict, about Meghan's allegedly harsh characterizations of her siblings, about whether her Oprah interview statements crossed ethical lines. The victory didn't erase the controversy, it prolonged it. There's also the emotional toll. Litigation is warfare. It's emotionally draining, even for those with unlimited resources. Depositions, document production, public court hearings, appeals, these are not pleasant experiences. They require constant engagement with adversarial processes. For someone as image-conscious as Meghan, this constant legal entanglement must be mentally taxing. And yet, she continues, the legal strategy appears non-negotiable. Perhaps it's become part of her identity now. The Duchess who fights back. The public figure who doesn't accept disrespect. The woman who uses every legal tool available to protect her interests and her image. Now here's the fundamental legal paradox that defines Meghan's litigation strategy. She's a public figure. By definition, public figures have reduced privacy rights. They've voluntarily entered the public sphere. They benefit from public attention. Consequently, they have less legal protection against invasion of privacy or media intrusion than private citizens. Yet Meghan's legal victories, particularly the Associated Newspapers case, have established that even public figures maintain some privacy rights. The courts have found that certain information is so personal, so intimate, that even public figures have reasonable expectations that it remains private. A handwritten letter to one's estranged father qualifies. Personal family correspondence qualifies. But here's where it gets complicated. Meghan, through her Netflix series, through interviews, through her public statements, has voluntarily disclosed enormous amounts of personal information. She's discussed her family relationships, her mental health struggles, her difficulties with the press, her perspective on her marriage. In doing so, hasn't she waived some expectation of privacy? Legal scholars debate this endlessly. The courts so far have sided with Meghan's interpretation. But that interpretation creates a unique position. A public figure who can leverage her celebrity to generate publicity and profit from
Dude's saga is completely dead and buried, and you're not going to hear anything more about that. Well, you've got another thing coming, because the Samantha Markle legal team filed an appeal to the United States Court of Appeals for the 11th Circuit, asking the appeals court to reverse the decision by the district court judge to dismiss this case.
Its focus on the most recent development because it's still unfolding. The Samantha Markle appeal in September 2025 is significant for multiple reasons. First, it shows that family conflict, once litigated, doesn't simply end. It continues through appeals, through new legal theories, through persistent efforts to overturn unfavorable rulings. Samantha lost at the trial court level, but she's fighting on. Her attorney, Peter Ticktin, of the Ticktin Law Group, has built an appellate strategy that attempts to circumvent previous legal rulings. During the oral arguments before the three-judge appellate panel, Ticktin argued that Meghan's statements about Samantha were deliberately destructive. He alleged that Meghan intended to harm Samantha's reputation and that the lower court should have allowed the defamation case to proceed to trial. He claimed the whole purpose of Meghan's characterizations was to destroy Samantha. But here's where the appellate judges seemed skeptical. Meghan's attorney, Michael Kump, pointed out that Samantha had essentially abandoned most of her claims. The appellate theory was narrow and, arguably, convoluted. The judges pressed Samantha's legal team on inconsistencies. They questioned whether the legal theory actually supported a viable defamation claim. The indication from the oral arguments was that the appellate court would likely affirm the lower court's dismissal, but that outcome isn't certain. The decision could take weeks or months to arrive. And regardless of the outcome, what's clear is that Meghan's legal exposure doesn't end with trial court victories. Her statements, her characterizations, her public narrative all remain subject to legal challenge. What's also clear is that Samantha won't accept defeat easily. If the appeals court rules against her, she could potentially petition for further review. The family conflict, once private, is now ensconced in the legal system. And the legal system, by its nature, is slow, tedious, and designed to drag things out through multiple levels of review. First, there will be more lawsuits, not necessarily initiated by Meghan, but against her. Family members, media organizations, and others she's characterized or criticized will continue to pursue legal action. The Samantha Markle appeal is likely just the beginning. Expect challenges to her statements, her portrayals, her public characterizations of people and events. Second, privacy law will continue to be refined through her cases. Whether Meghan likes it or not, her litigation is creating legal precedent that will impact how courts handle privacy cases for decades. The Associated Newspaper's ruling is already cited in legal proceedings around the world. Future cases will build on that foundation. Third, the reputational impact of constant litigation is unlikely to fade. Once someone becomes known for aggressive legal action, that characterization sticks. Meghan can win every single case and still be perceived as litigious. The narrative has taken hold in certain segments of the media and public consciousness. Fourth, international legal considerations will become more complex. Meghan and Harry operate across multiple jurisdictions: the UK, the US, Canada. Different legal systems have different standards for privacy, defamation, and invasion of privacy. Coordinating legal strategies across jurisdictions is complicated and costly. Finally, the relationship between legal victory and public relations outcome may continue to diverge. Meghan can win in court while losing in the court of public opinion. The Samantha defamation case is illustrative. Even though Meghan won, the case itself was a PR challenge. It highlighted family conflict. It gave Samantha a platform to air grievances. It created headlines that kept the controversy alive. Here's the existential question that underlies all of Meghan's litigation. Does legal action actually solve anything? The Associated Newspaper's case established privacy rights, but it didn't repair Meghan's relationship with her father. If anything, the legal proceedings made the estrangement more public, more permanent. The case won, but the underlying family conflict remained unresolved. The paparazzi lawsuits won settlements and bankrupted at least one company, but paparazzi still pursue Meghan and Harry. The desire to photograph celebrities for profit remains economic incentive. Legal action creates friction, but doesn't eliminate the fundamental market demand for celebrity photography. The Samantha defamation case, even if Meghan wins on appeal, won't reconcile the siblings. it won't change how Samantha feels about her portrayal in the Netflix series or in the Oprah interview. The legal system can determine liability, but it can't manufacture genuine family reconciliation. This is the paradox of litigation as a problem-solving mechanism. It can assign blame, it can award damages, it can establish precedent, but it cannot resolve emotional wounds, repair broken relationships, or eliminate underlying conflicts. If anything, it often intensifies them. Meghan's legal strategy speaks to a worldview in which problems are solvable through assertion of rights and through the legal system. If someone wrongs you, sue. If someone invades your privacy, litigate. If someone defames you, take them to court. It's a rational, systematic approach. It's also, potentially, an endless cycle. So where does this leave us? What is Meghan's litigation legacy? On one level, it's impressive. She's won significant legal victories. She's expanded privacy protections in ways that benefit all people concerned about surveillance and intrusion. She's made clear that she won't accept disrespect or invasion of privacy without legal consequence. She's used the legal system effectively to protect her interests and advance her position. On another level, it's a cautionary tale about the costs of constant legal conflict, about the ways litigation can consume life and energy, about how legal victories don't always translate to peace or resolution, about how being known as someone who sues can become as defining as any actual legal outcome. For Meghan, moving forward, the challenge is whether she can transition from being a figure defined by legal conflict to something else. Can she build her brand and her life without constant litigation? Can her Netflix deals, her Archewell Foundation work, her public statements generate meaning without legal controversy? The Samantha appeal outcome will be one indicator. But regardless of how that case concludes, one thing is clear. Meghan Markle has used the legal system extensively, aggressively, and often successfully. She's created precedent. She's influenced how courts think about privacy and public figures. She's also created a narrative around herself as a litigious figure willing to fight through courts to protect her interests. Whether that legacy will ultimately serve her interests or complicate them remains to be seen. But what's undeniable is that Meghan's legal battles are part of her story now. They're woven into how people understand her, how media covers her, how the public perceives her. The lawsuits have become inseparable from the person, and that perhaps is the real victory or the real cost, depending on your perspective.